Yes.
Well, I have some quiet talk.
No, I'm not a quiet talker. This is the level I will talk at, and I might get more excited if something. What is this film about? You told me ancient stuff.
Oh, well, so we're looking at really four main types of mining in the Southwest.
Oh, mining.
Yeah.
Yes, I totally forgot.
Yeah. Well, the documentary's focus, I suppose, is on the mining. Uranium mining, copper mining, coal mining, and oil drilling. And we've looked at the way that affects the Dene, the Apache, the Ute. There's a lot of moving components in that. But the thing that interests me the most is the way the land is set up throughout for indigenous people on reservations across this nation. If you are someone who was like me a few years ago and had no clue about the difference between regular land and native land and how the law separates them, how would you describe that difference?
We're on live now?
Yeah.
Okay. As part of American history, Indian tribes were never deemed to own their land, what we call the fee simple title absolute. That comes from English and American property law. When you and I buy a home just here in Phoenix, we receive what's called the fee simple title. You have certain rights with that title. The four main ones that we are taught in property law when you go to law school is that you can exclude anyone you want. You can use your property in almost any way you want. You can sell it to anyone you want for any amount. If you want to give it to your kids for $1, if you want to give it to charity, if you can get someone to give you $1 million for it, more power to you. So that's how most Americans own their land. But the United States and the Europeans that came to this continent had a new theory, a theory of colonization. I call it the international law of colonization. And in the United States, it's better known as the Doctrine of Discovery, because how that principle was applied to Indian nations comes from a case in 1823, Johnson v. McIntosh, drafted by the famous Chief Justice John Marshall, in which he defined what rights tribes had to sovereignty and what rights they had to their own lands and to the assets that they had owned, 100% owned and occupied and used before Europeans showed up. So do you want me just to keep on talking, or
talk then about what rights I guess natives do have with their land, what they don't have with their land?
I mean, I can finish that case description in just a few sentences. Sure. Yes.
Yeah.
So in Johnson, Chief Justice Marshall and the Supreme Court looked back at European history. It was already, the European history of colonization was 400 years old by then. It was set forth really by the Catholic Church in papal bulls, bulls, those are orders of the Pope, and by Spain and Portugal as they attempted to colonize the entire world. In 1493, Pope Alexander VI issued 3 papal bulls, and he divided the world in half through the Atlantic Ocean for Portugal to colonize and to conquer and to acquire sovereignty, jurisdiction, and title to all lands east of that line. So that was all of modern-day Africa, and later, as they found out, a lot of Asia. And Spain was granted that same rights west of that line to conquer, acquire title, sovereignty, and jurisdiction. And so Spain and Portugal, they claimed the entire world. They did not want England, France, and Holland interfering with their Vatican, God-given rights to colonize the entire world. So 400 years later, in 1823, Chief Justice John Marshall in Johnson v. McIntosh has to decide what rights Indian tribes own in their lands. What's funny, you'll notice there's no Indian-sounding name in that title, is there? Johnson v. McIntosh. These were 2 American white males arguing over land in what's now Illinois. And the argument was, had the tribes sold their lands, the fee simple title, to Mr. Johnson's grandfather in 1773 and 1775. That's what the case is about, is land purchases made, allegedly, we don't even know if they really happened, but allegedly made by English citizens in 1773 and 1775 from Indian native peoples in the woods of Illinois and Indiana. Mr. McIntosh, on the other hand, was an American who had bought the land from the United States in 1818 who had signed a treaty with these same tribes, the Illinois and Piankashaw peoples, in 1813. So the United States claimed to have acquired the Indian title in 1813 and now sold it to Mr. McIntosh. So who had the legal right to be on that land and to farm it and use it? Mr. Johnson or Mr. McIntosh? And so Chief Justice John Marshall, in about a 30-page opinion, looks back a little bit at this European history I just mentioned, this international law of colonialism that England, France, Holland, Spain, Portugal all had finally agreed upon how to divide the world. And they came up with this doctrine of discovery. I have written a book in 2006. I break it down into 10 elements, 10 justifications why European Christians deserve to own the whole world over the indigenous peoples everywhere. And that's really, Johnson v. McIntosh adopted that case, adopted that legal principle. And so what did Indian tribes own? Well, Marshall uses the phrase Indian title, and the Supreme Court uses that phrase only a few other times, but a lot of state courts here in the U.S. use the phrase Indian title. What do tribal peoples, and what does the tribe as a group, what does it still own under American property law? Well, I can tell you, it's not the fee simple title. And so in Johnson v. McIntosh, the court defines very clearly that Indian peoples have the right to live on, occupy is the word Johnson uses, and to farm and to use the land as long as they're still in existence, as long as the United States hasn't either conquered it from them or bought it from them in a treaty.
So the only legal difference or legal threshold for an indigenous person having land is that it has not been conquered by the United States proper. That is it the treaty that gives them a specific the proof that they're not conquered? How does that legal process work? How do you prove you're not conquered?
Well, that's an interesting point. And what I argue, my 10 points, is that Chief Justice Marshall, he not only talked about conquest in the legal sense, but I think he was using the metaphysical sense that if Europeans showed up with their cross and their flag, that was as if they had just conquered the native peoples. Because the European countries claimed these rights that I'm talking about, these 10 elements that I defined clear back in, 20 years ago. So your question, and I didn't quite finish, so what do tribes still own? Most of your audience has probably heard of the phrase trust lands, Indian trust lands. What does that mean? That means the United States is the legal owner of Indian lands, tribally owned, and some individual Indians, and the tribal nation, or the individual Indian, is the beneficial owner. That's what we call it in American property law. Your parents could own land for your benefit, and when you were under 18, they would have to be the legal owner. But you would be the beneficial owner, like if your grandparents had left you some property, and then only when you finally reached adulthood would that guardianship of your parents go away. Well, this guardianship relationship of the United States to Indian nations is never going to go away. The Supreme Court also defined this in several cases. Chief Justice Marshall, again, in 1831, wrote the opinion in Cherokee Nation versus Georgia, and he said tribes are domestic, dependent nations. They're inside the United States, and they're subject to this overriding power of the United States. And then he made this very famous statement that the tribes and their relationship to the United States is like a ward to its guardian. So the court sort of borrowed from what today we would call trust law, where a guardian owes duties to look out for the property. If you're the beneficiary, your trustee, your guardian, is supposed to look out for your best benefit. And that is, in a nutshell, how the United States trust duty towards Indian peoples, what it is, why it exists, is this international law of colonialism, this fraud of the Doctrine of Discovery, that because Europeans were Christians and they were civilized, they had the right to go around the world claiming it all. But the only thing you can say is that's still law in the United States today. So and let me say one more thing. Why do we call lands reservations? You mentioned treaties a moment ago. So if a tribe kind of hunted on, and my own tribe, we lived in southern Ohio and Kentucky, was sort of our hunting grounds, and we shared that with some other tribes. But that was territory we defended. We tried to fight against the Daniel Boones of the world. That's our land. We used the resources from there. But now I forgot what I was going to say about that.
You were talking about the reservations and why
Oh
we still
yes,
use
thank
this
you.
term.
So when the United States came to us and said, well, we'd like to buy some of these lands, and yes, we fought wars with the United States. We won a couple of them big time. The biggest defeat the United States has ever suffered was at the hands of Shawnee, Delaware, and Miami peoples in 1791. Most of the army of the United States was like wiped out and routed in that battle. Most people don't know anything about it. But when the United States then came to treaty with us, what did it do? It offered us money. It drew boundary lines where it would recognize what was Indian lands. And the reason we call these lands reservations today is because while a tribe maybe owned, like I mentioned, all of Kentucky and a lot of what's modern-day Ohio, we agreed to withdraw to certain areas. We reserved those lands for ourselves from a much greater scope. And so that's where we get the word reservations. In Canada, they call the homelands of the First Nation peoples, they call them reserves. So it's the identical same legal property issue. The tribal peoples owned and used all these lands and all these resources, and now they've agreed to withdraw to a certain area for payments, promises, safety, hopefully termination of war.
Now, what are the kind of authorities that the trust holders, our government, have over the trustees, the indigenous peoples?
Well, the Supreme Court has decided these cases many times over the years. Johnson v. McIntosh starts in 1831 that the U.S. is supposed to be like our guardian. Wow. Does the old saying, having the fox in charge of the hen house, mean anything to you? That's exactly what it was. So the United States is probably sued 4 or 5 times every single year by tribes under claims of breach of trust responsibility. In 1942, the Supreme Court wrote a case, Seminole Nation versus United States, and set out a strong definition of what the trust responsibility means. The United States is supposed to look out for the best interest of tribal peoples and tribal nations, and that the United States has taken this duty on voluntarily. So now I've almost forgotten your question, but how has it worked out? Well, to our harm, mostly. How much land do tribal people still own these days? About 1% of the United States. We, of course, used to own it all. So much for the trust responsibility. But let me back up just one step, because the Constitution talks about the power of Congress to control commerce with the Indian nations. It's in Article 1, Section 8, Clause 3 of the Constitution. It's called the Interstate Commerce Clause, also known as the Indian Commerce Clause. That's the only specific reference to tribes in the Constitution. But how the Supreme Court has read that clause to this day is that Congress can do almost anything it wants, good or bad, to Indian nations and to Indian peoples as citizens of their nations. So I'm a citizen of a federally recognized tribe. So the United States, I'm kind of in a different category than other citizens who are not Indian peoples. And some statutes that Congress has passed apply to me. And my tribal government can pass laws that apply to me that do not apply to the average person on the street out there. So Indian law is a pretty complicated collection of case law for 240 years, the Doctrine of Discovery from 400 years, and the relations between the dominant European, Euro-American society and indigenous peoples. So we could talk for about 4 hours or 10 hours on this subject.
Well, I definitely could. So maybe the best thing then is just to kind of get at the heart of what I'm really curious about. This difference between indigenous law that governs these First Nations and everyone else. Is this a form of segregation? Would that be inaccurate to call it that?
Segregation. Well, I have not heard someone use the word that way. I thought you were going to ask me, is this diversity, equity, and inclusion when the United States does something for or against Native peoples? I literally wrote a little one-piece paper one-page piece of paper for someone on this topic, an Indian organization. Indian law is based on a political diplomatic relationship. It comes from Article 1, Section 8, Clause 3 of the Constitution. It comes also from Article 1 and the 14th Amendment, because Indian peoples are citizens of their own nations. Indian peoples were not counted in the U.S. population or in the state population until 1924, when all Indians were made U.S. citizens. So that's because the founding fathers of the Constitution realized that we were citizens of our own governments, governments that the United States had a political relationship with. So Indian law is based on politics, diplomacy, and treaty making. And it's not some sort of race-based, or as you asked about, segregation. So if Congress passes a law that benefits tribal peoples or maybe hurts us in some way, you can't really make an argument that that's racial discrimination and we need affirmative action to do the contra, because it's just in a different category. And the Supreme Court has long recognized that Indian laws and Congress's actions in Indian laws come from the Constitution and comes from this existence of tribes as governments who deal with the United States through treaty making and political negotiations, not through an affirmative action type situation.
That's a really interesting answer to that. So maybe just to wrap up here, could I do some like rapid fire questions of?
Well, we never got to the land. If you want me to just say a few more things and we get to mining, or do you want your questions?
Sure.
Let me say a few things about mining
if you have
and why
something to say, I would be welcome to whatever you want.
Yeah, absolutely.
That's always good things for us.
Okay. So this ownership of Indian lands by the United States as the legal owner and the tribe is only the beneficial owner means that if the tribes want to do something, they need the permission of the United States. Congress passed a law that is still the law today. July 22, 1790, Congress took the power that Article 1 of the Constitution gave it, and it took control over any sales or any use of Indian lands. And Congress had to approve of Indian sales of their lands. So this was really the answer to the Johnson v. McIntosh case. Mr. Johnson and his grandfather, they couldn't just buy land from Indian peoples in the woods because they don't own the fee simple title. They are the beneficial owner, and the United States is the legal owner. So tribes cannot develop, sell, or lease their lands without the permission of the United States. There are 11 million acres of land are owned in the lower 48 states by Indian individuals in trust with the United States. It's a leftover of federal Indian policies, what's called the allotment era of federal Indian policy from 1887. These individual Indians cannot sell their land, they cannot lease their land, they cannot develop their land without the permission of the United States, because once again, the U.S. holds the legal title, the Indian only owns the beneficial title. So when it comes to mining, if a tribe wants to mine, it can't do that without the permission of the United States. There are laws since 1928. There's the Indian Mineral Leasing Act from 1938. There's more recent laws, 2005, about mining. And so the feds take control of that and have to approve. Now, quite a few tribes do mine, and some make a lot of bit of money off of it. So you're in a topic here where there's maybe a little give and take. You mentioned Utah. Well, the Southern Ute tribe has a trust fund worth about $4 billion. Because of the money they've made, I think, off of oil and gas. So you might get a different answer there about oil and gas than you might at San Carlos, who's trying to stop this copper mine off the reservation. So I just said a key word. Let me just wrap up, though. But for mining to occur in Indian country, inside a reservation, the United States would probably not do it if the tribe resisted. Now, I'm not talking 100 years ago when the U.S. just did anything it wanted. We're in a different era of federal Indian policy today. But I just mentioned the San Carlos and that copper mine. That's land off their reservation. That's land that their ancestors sold, 100 years ago to the United States. And so they're bringing religious claims, cultural claims, but they don't own those lands anymore. And that severely limits what they can do to protect that land.
Isn't the fear then about owning land privately as indigenous people the loss that is occurred when it is given to white settlers, and how then the Apaches in their history sold Oak Flat, quote unquote, sold it, and that deal essentially is what the U.S. exploits to control that land today. Today they couldn't do that because they don't even own the land. Isn't loss of land a fear when selling land about owning land? Isn't that kind of the fear many indigenous people have about the thought of land in the nations being kind of freed up that way?
Yeah, I didn't follow your question at first, but I don't think there's a single group of people, native peoples, that would want to sell a single acre of land. I was just reading my own tribe's tribal newsletter from April. In 1984, we owned 58 acres of land. We started a casino. We started making some money. We now have bought and taken into trust, so the United States is the legal owner, we're the beneficial owner, of over 4,000 acres. And we are very proud of that. So I think almost no tribal group, I think I can generalize about this, no Indian reservation would want to sell any of their land. But history is a different story. When you've lost a battle, or you're starving to death, and here comes the military and they force you to go live somewhere. Yeah, I mean, what happened to San Carlos and other tribes, I'm not an expert on their history, but somehow that Oak Flat did not end up in their reservation, so it greatly diminishes what their power is to control it. There's a Supreme Court case you should don't know about, and I just sort of sit and go, wow, good luck, San Carlos. The same issue has arisen by many tribes in many different places in the U.S., but some tribes in Northern California tried to stop the building of a road to help timber cutting because it went through a sacred site where their medicine people went to meditate and on power quests. Is that the right word? Maybe I'm saying the wrong word, but where they gained spiritual power and they need quiet and they sit in the high mountains, and here the Forest Service was going to build a road through there. The Supreme Court said, too bad, and literally they said, you don't own that land. It's like you're trying to tell the government what to do with its own property. And so this is the Ling case. It's called Northwest Indian Cemetery Protective Association. That's a long title. Northwest Indian Cemetery Protective Association versus Ling, L-Y-N-G. He was the Secretary of Agriculture who's in charge of the Forest Service. And the tribe had won in the federal district court and had won in the Ninth Circuit Court of Appeals. And then they lose this Ling case in the U.S. Supreme Court. So that's a big precedent that's very problematic for tribes to protect lands off their reservation for their cultural and religious purposes. So here in Arizona, the Navajo Nation, Hopi, and other tribes fought to try to protect the Snow Bowl, to stop the Snow Bowl ski resort from putting recycled water and snow on that mountain, which I'm blanking on the name of the mountain. And they lost those cases because of Ling. And so I'm very pessimistic about what, I hate to even say this, I don't like saying this on tape, I'm very pessimistic about what will happen with the Oak Flat case. And so far the tribe has lost, and the Supreme Court, I think, has 2 times turned down even to consider it. So you're talking about mining. I don't know very much about mining. I've been following this Oak Flat situation for the last 6 or 7 years it's been going on. I wrote an article on the Ling case from Northern California, so I know the precedent that tribes are up against when they're trying to stop mining or any kind of development on lands they no longer own. It's very problematic.
I think you've covered everything we could possibly want to talk about in terms of the way land and mining can finally, like, that story makes sense of how you get from conquerors to the mining of land. That's put together really well, I think, just in your ability to lecture on that. The last thing then maybe I think I'm just more personally curious about then is the intertribal conflict that can sometimes arise. Specifically that we've seen that's very interesting is the Hopi Dene conflict in Black Mesa, where there are Dene living on the Black Mesa, which is technically Hopi land, and as well as Jedito Island, which is the weird part of the Navajo Nation reservation that's inside Hopi Nation, that's inside Navajo Nation. So
I was unaware of that last
Oh yeah,
reference.
yeah. We went and spoke to a man in Jedito Island, and he lives like in a reservation, in a reservation, in a reservation. It's an insane. It's a very interesting conflict of land interests, and it's ongoing because I don't think even our own court systems can quite make heads or tails of how to resolve some of those issues. And it's all revolving around Peabody coal mining in that region. Of
Well,
course.
Congress has passed a law or two about the Navajo Hopi issue. I'm no expert on those subjects. It continues to be a mess today, as you just said.
What does the future then look like for indigenous land law? Are we increasing towards liberation and independent means of organizing, or are we moving away from it? Are we losing rights?
I don't think we're losing rights because tribes have more power. They have more money. Many tribes, because of gaming or other economic activities, we hire lawyers now, and we know how to lobby. Some commentators say that Congress has not passed a law that tribes were against since 1968. So the tribes know how to lobby, and they have, like I said, some resources to bring to bear. Let's see, I was going to say something else.
They have a lot of resources like game that can.
Well,
help you develop the
that was a
resources.
side issue of where I was headed. What did you really just ask about?
You said we're not losing rights. They have
Okay,
more
not
power.
losing. Exactly. So when I was practicing law, we were advising tribes to buy land and keep it in fee simple absolute, so that the federal government didn't have any voice in what the tribe did with their land. So that's still an option today, to avoid the trust land situation with the U.S. as the legal owner. But the Supreme Court decided cases in 1992 and 1998 that if a tribe keeps land in fee, even inside a reservation, which is that's the borders of that tribe's lands, the state can charge annual, what are called ad valorem taxes, the value of the property every year. And so most tribes now, to avoid that very expensive tax that goes to the state, doggone it, take their land into trust. So I mentioned my own tribe recently. Every time we find a farm that's available, that's for sale within our area, or a ranch, we try to buy it. And we instantly take it into trust. And I mean, I've never talked to my chief to know why we do that, but I'll bet it's because of those Supreme Court cases from 92 and 98. If you keep it in fee simple, the state can tax you every single year. So that just shouldn't be. One government, in my opinion, shouldn't be allowed to tax another government. They're separate government entities, do their own thing. And so if tribes wanted to be free of the federal yoke, then you keep the land in fee simple. But then you're kind of under the state yoke. So it's sort of the devil you know versus the devil you don't know. And states and tribes have never gotten along well. It's like oil and water. So we're used to dealing with the federal government, and we're pretty successful, as I mentioned to you, with Congress not passing a law the tribes opposed for over 70 years now. That's a pretty good, that's power, and we're using more and more power every day.
Well, I think you've given me personally just a really in-depth understanding of that process of how, you know, the church tries to mitigate the conflict of colonization, and how those land claims have kind of continually spiraled into more and more legal cases. I really appreciate you breaking down the Supreme Court cases for me too, because
Sure.
being a student right now, that's what I'm used to, is looking at court cases and seeing what the implications are. For people like myself who had to learn about this in a very short amount of time, and then this is still their only introduction to this kind of law containing an entire people within the nation, what do they need to know walking away? Because leaving off, it's, if you have anything that would just be helpful to someone who doesn't know the heads or tails of all of this.
Well, of course, I'd love to recommend you read some of my books, but it's such a big topic that, I mean, it's like I don't even know what to say to read. Grab that book right above. You see that big black one? Look, grab the one on top of it. So if a person, this is the as you can see, a well-used edition. But this is, I think, the 5th edition of Judge Canby's Indian Law in a Nutshell. And I think it's now 2 more editions. There's either a 7th or even an 8th edition. And this is, he's a Ninth Circuit judge, so he's not a federal trial court judge. He's a federal appellate court judge, right below the U.S. Supreme Court. He lives right here in Phoenix. So he has written 6, 7, 8 editions of this book to keep up with the changes in federal Indian law. So you can see they call it in a nutshell because it's tiny pages and not so long. But if you wanted to read about colonization, then read my first book, Native America Discovered and Conquered. It's all about this doctrine of discovery and the claims the U.S., ultimately it's the U.S., at first it was England, France, Holland, Spain, here in the United States, what's now the U.S., how they claim these rights over Indian peoples, and what it has become to this day. And I argue the longest chapter in that book of mine is that American Manifest Destiny. I'd like to ask you or your audience, when you say those words, what does that mean to you? We studied it a little bit in school, but what is manifest destiny? I try to prove in my book, and I think I succeed, that it's just this doctrine of discovery. It's this international law of colonialism used by the United States against Indian nations as the U.S. advanced across the continent. So I'd recommend you read that book. If you want to read about Oklahoma and the most important case that's ever happened, Indian law, McGirt v. Oklahoma was decided in 2020, and I wrote a book on that case. So anyway, there are other people who wrote books and stuff, but if you really want the law, you go to Canby. You see the book that it was sitting on? That's Cohen's Handbook of Federal Indian Law, and that's about 1,500 pages long. So this one, I don't know that you'll want to read that one in your spare time. That's why people buy the Canby's Nutshell. But this is the Bible of Indian law. The United States Supreme Court cites Cohen's Handbook all the time. So it was drafted in 1941 by Felix Cohen. He was a federal employee who was told, make some sense out of Indian law. And he started writing this treatise. He's been long deceased, but other people have kept that book up to date.
Wow. Well, I'm going to do my best to get my hands on something like that at our Zimmerman library and see if I can make heads or tail of legal writing, because every time I dive into anything legal, I have to like read things 3 or 4 times and be like, I think I get what that whole paragraph is saying.
Law school is not so easy.
No,
well, if you have access to Lexis, this book is available on Lexis for free.
Oh, I think we do have that as students, so I will probably do it that way.
Now, you said you had some rapid fire questions. I covered them all?
You did. No, you actually did. You're a good lecturer. I can tell when someone has done speaking for a while. It's